Good afternoon, and thank you for joining our webinar, What Employers Should Expect in 2020. My name is Jenny Andrews, and I'm a Managing Director here with Sikich. Before we get started, I have a few housekeeping items I'd like to talk about. First, I encourage all of you as you go through the webinar today, if you have any questions, to please put them in the control panel under the questions section. List your comments, questions there. If we can't get to them during the webinar today, one of us will get back to you following the webinar. Secondly, the presentation slides can be downloaded from the handout section of the webinar control panel. Throughout the presentation today, there will be 3 polling questions that we will launch, and these will need to be answered in order to receive your CPE credit for attending today's presentation. At the conclusion of the webinar, a short survey will launch and people will need to complete the evaluation for CPE credit. Certificates will be emailed following the program. So let's get started. Ringing in the new year, I think we have seen that it has presented many exciting challenges for employers and business owners across the United States. In 2019, we've seen several trends influence and shape how we think about HR. Besides the trends, many legislative and regulatory movements at the state and federal levels have made a significant impact on employers and in the workplace. Although some of the changes did take place in 2019, others are taking effect this year in 2020. As we move forward in 2020, the workplace will continue to be shaken up, and employers are in for more changes as new and different challenges will emerge. Today, we will discuss 2019 most noteworthy developments in the employment law landscape and the trends we expect to continue into 2020. We'll look at some hot topics and trends, and walk away with some action items that we can look at to help keep you better prepared into moving into the new year. As an HR practitioner, I can relate and understand your pain and struggles. I appreciate you taking the time to attend the webinar with me today. So, what do you need to know to be able to perform your job effectively and efficiently? Our roles and responsibilities for managing human resources is continuously changing, not only from a compliance stance, but also for the various hats and responsibilities we're now managing. With the continuous changes taking place, our jobs are becoming more complex, and the time and effort needed to stay on top of all the changes to ensure that we're running the office, protecting our organization's assets, trying to avoid being sued by our employees or former employees, and trying to survive if the government should come knocking on our door. I think we can all agree that we're facing more challenges than ever before with no end in sight. The responsibilities become more challenging, especially if you're a multi-state employer or if you have remote workers in other states, counties, or cities other than your business operations. So employment law seems to always be changing. Things that were a big deal for the government 3 to 4 years ago aren't a big deal anymore. The number of changes are endless. Our alphabet soup of compliance. So we have our first polling question. How do you stay abreast of all the employment law changes? Newspaper, TV and newspaper, trade publications and industry blogs, networking and social media groups like SHRM or LinkedIn, third-party providers, insurance brokers, payroll providers, your legal counsel, etc., or other sources. Let's take a moment and answer the question. News, trade publication and industry blogs, networking and social media groups, third-party providers, or other. Looks like we're almost there. Okay, we're going to close the poll. 6% of you said that you get your information from news, which would be either the TV or the newspaper. 27% from trade publications and industry blogs. 26% from networking or social media groups, such as SHRM or LinkedIn. 36% get it from third-party providers, your insurance broker, payroll providers, or your legal counsel. And 6% say other. Thank you. So let's take a look back at 2019. I think you all agree that it was a very busy year with all the legislative changes, not only at the federal level, but at the state level, and in some cases at the municipality level as well, with the counties, cities, etc., everyone jumping on the bandwagon. So let's take a look at some of those challenges. In compliance, which was very big, we had the EEOC, Department of Labor, ICE. We had federal changes, state changes, and as I mentioned, municipalities, cities, counties, etc. You had challenges with workforce planning, recruiting, finding that right person to fill those jobs, and retaining that top talent. Offering competitive compensation, digital security, privacy, and doing whatever you could to prevent breaches in your data. Adapting to technology and innovations, doing process automation, process improvement. Offering competitive benefits and work-life balance. Training and developing your staff. Workplace diversity, managing your employee leaves, and the hashtag #MeToo movement and equality. So let's take a look at some of the legislative and regulatory trends that we were all looking at and dealing with in 2019. A big one was workplace violence, offering safety and ensuring safety in the workplace. The Me Too movement and more focus on harassment, policies, and training. Pay equity laws, gender diversity, identity and discrimination. Compliance with focus on the I-9s and the ISIS raids. The Department of Labor Fair Labor Standard clarity on regular rate and overtime pay requirements. Paid family leave and other paid leaves started becoming very popular. Medical and recreational marijuana. Pay history inquiries and banning the box. Domestic violence protection. And minimum wage increase. With just minimum wage alone, more than 25 states and local areas increase their minimum wages, often significantly well above the federal minimum wage of $7.25 an hour. So again, if you're a multi-state employer, that was something that you always have to contend with and manage. Harassment. We have 3 big changes in 2019. Connecticut expanded its requirements for training and posting obligations. Illinois enacted the workplace harassment training law and new obligations for employers. And New York implemented significant changes to its harassment laws. Equal pay and wage transparency laws. We've seen many states and cities adopt changes, with pay equity continuing to be a priority both at a corporate initiative and legislative concern. Recent studies and surveys have showed that most private employers are voluntarily conducting workforce pay equity analysis to identify and address any discrepancies and disparities. and we're looking at this trend likely to continue. The reasons most are citing that they're doing this is to build a culture of trust, eliminate bias in pay policies, and because it just makes business sense to do so. Additionally, we're looking at many more states that are continuing to propose and enact a variety of pay equity laws with specific requirements such as salary history ban and wage discussion protections. And as you see on the screen, I've listed several right now states or cities that have salary history bans. Paid family leave and FMLA changes. This has become something that was thrown around a little bit more in 2019 and will continue on to 2020. You have the District of Columbia, effective 7/1 of 2019. They began collecting taxes from its private sector employer organizations and non-for-profit to fund a new paid family leave benefit. Massachusetts, New Jersey, Oregon, they passed a paid family medical leave law providing up to 12 weeks of paid medical leave beginning in January of 2023. You have Washington, and with FMLA, you're looking at, in the department, they had significant changes come through from the Department of Labor. There was an opinion letter dated August 8th of 2019 that the Department of Labor clarified that parents can now take FMLA leave time off to attend special education meetings. So that they're calling it the individualized education program meetings for children with serious health conditions. They also clarified that once an employer knows that a leave of absence qualifies under FMLA, it must designate it as such, even if the employee wants to first exhaust paid leave benefits. So they must run concurrently, and therefore basically saying that an employee cannot decline benefit. They can't say, I don't want to take my FMLA. Other paid leaves that are coming up, in Duluth, Minnesota, they had the Sick and Safe Time Ordinance, which just went into effect at the beginning of this year. Nevada, to provide 40 hours of paid leave without providing a reason. And there's a twist that we're starting to see a little bit more, where the employee can take the sick time without having to clarify. We've got Pittsburgh, Pennsylvania, which has Paid Sick Days Act, which will take effective in March of this year. The medical and recreational marijuana. Illinois just passed the Cannabis Regulations and Tax Act for marijuana for recreational purposes effective the beginning of this year. New Jersey gave job protection to medical marijuana users. And New York City will be enacting legislation to prohibit prospective employees to submit to testing for the presence of THC. As more and more states start approving medical marijuana and recreational use, employers are going to have to understand the relevant legal developments and how they're going to affect their workplace. Another challenge is the growing popularity of the cannabis oil, which is leading to more positive test results for THC and the impact on it will have for the testing, for the drug testing. Discrimination laws that we've seen. California, they created a Respectful and Open Workplace for Natural Hair, or CROWN Act, which clarified the definition of race for purposes of workplace discrimination to include hair texture and protective hairstyles. New Jersey also implemented its own version of the CROWN Act in December of this past year. And New York City is looking at the same act and saying that it could, restrictions of natural hair or hairstyle could be unlawful under the New York City human rights law. One of the bigger changes that impacted all employers this year or last year was the Fair Labor Standards Act final ruling on overtime. On September 24th of 2019, they released the final rule updates. While there was no changes to the duty test, they did increase the minimum salary threshold to $684 a week, or $35,568 per year for a full year worker. That's raising the standard salary level from $455 a week that it was previously. Also increased the highly compensation allowance for employees. It also is allowing employers to use non-discretionary bonus and incentive payments paid at least annually to satisfy up to 10% of the standard salary level. And it's revising the special salary levels for workers in U.S. territories and the motion picture industry. There was also offered clarity on what regular pay is, how it's defined. For the first time in over 60 years, the Department of Labor on December 12th of 2019 issued a final rule updating its interpretive guidance with respect to permissible exclusions from the regular pay rate. According to the Department of Labor, the proposed rule is intended to better reflect the modern workplace and provide clarity to employers on what types of compensations, benefits, or perks may be excluded from regular rate. The final rule was published on December 16th of 2019 with an effective date of January 1st of 2020. So, for example, the following could be excluded from regular rate when you're calculating overtime pay: discretionary bonuses, payments made when no work is performed, such as vacation or holiday pay, gifts, parking benefits, wellness program, on-site treatment programs, gym access, fitness classes, certain tuition benefits, adoption assistance, payments for travel expenses, and complimentary office coffee and snacks. And just a reminder, a copy of the presentation is available under the handout section in the control panel, if you have not already downloaded that. Okay. So we have more challenges than ever before with no end in sight. I think we all can agree with that. Especially with this becoming an election year, you're going to have more and more changes coming through. So what are we going to be facing in 2020? Let's take our second polling question. What employment law or regulation will present the biggest challenge for your company in 2020? Wage and compensation, such as minimum wage, overtime challenges, or pay equity laws. Employment leaves, such as paid family, medical, or parental leaves, determining the leave law requirements. Your overall business strategies for employment leave, or reasonable accommodations. Or how about employee handbooks? Just keeping it current, incorporating all the local requirements, looking at the National Labor Relations Board decisions and how it impacts any of your policies. If you're a multi-state employer, trying to capture all of the state laws, or how to keep your handbook aligned with your business objectives. Marijuana and drug testing, or preventing cyber breaches and maintaining your data security. Which one do you see to be the biggest challenge for your company this year? Maybe we should have had one that said all of the above. Okay. Thank you for taking the poll. Let's see what we have here. First of all, 37% said that wages and compensation would be their biggest challenge. 12% said employee leaves. 16% said employee handbooks. 19% said marijuana and drug testing. And the other 19% said preventing cyber breaches and maintaining data security. Okay. So let's take a look at what's trending and carrying over into 2020. So we have sexual harassment and discrimination laws, state laws now on non-disclosure preventions in settlement agreements, developments in connection with pay equity and salary history ban laws, development in connection with agreements to arbitrate employee disputes, legislative and other attempts to limit restrictive covenant agreements, legislative efforts to regulate independent contractor calculations or classifications, developments in overtime requirements and regulations, and development in regulating employee biometric data and privacy issues. So let's take a deeper dive. Let's take a look at the federal level what we've seen. So first of all, we have the new Form W-4 for employee withholdings that was effective 1/1 of 2020. And it had major revisions designed to make the accurate income tax withholding easier for employees. The one piece out of that was that existing employees were not required to complete a new form. All new hires are required to use it as of 1/1. The new form included 5 possible steps for declaring additional income so that employees could adjust their withholding with varying levels of accuracy, privacy, and ease of use. And the IRS also updated their tax withholding estimator tool, which is available on their IRS website. I'm sure many of you, as I heard from some of my colleagues, were struggling with their payroll application on how to put in the exemption number versus now $1. You have the new Form I-9 that was just released on February 3rd with an expiration date of October 31st of 2022. And employers have until the beginning of May to convert over and start using that new form. FLSA overtime pay. And the calculations, the new salary cutoff, minimum wage changes, and privacy and data and cybersecurity changes. Okay. So let's take a look at one of the bigger ones, the sexual harassment, which in wake of the #MeToo movement and following the employee protectionist trend observing in other states and municipalities, it continues to enhance the sexual harassment prevention legislation, including employer training requirements. So as you can see here, there are some states. California was in 2018 had those requirements. Delaware, the District of Columbia, New York State, New York City passed laws with specific training requirements. In 2019, Connecticut expanded its training requirements. And then Illinois and Washington passed new laws with specific training requirements as well. Under Washington, hotel and motels went into effect this year, and all other employees will be effective next year. Privacy and data and cybersecurity. There was many laws that are starting to be enacted, and they will continue to be. California's is considered to be the most expansive privacy legislation in the US, which was effective 1/1 of this year. It provides new rights for consumers on info collected, how it's used, and obligations to employers or to companies for handling breaches. AB 25, as it's called, a recently passed amendment, creates specific obligations for employment-related personal information for a 1-year period, during which the legislator will consider more comprehensive employment privacy legislation. So under these obligations, under the Consumer Privacy Act, an employee in California is considered a consumer under the employer. So therefore, you have to notify all employees, applicants, and contractors of the categories of personal information that is collected by the business and the uses of those categories, and what safeguards you're putting into place to protect that personal information. In the state of Illinois, you have the Biometrics Information Privacy Act. Washington and Texas have similar laws to Illinois. You have some proposed legislation in several states. Some states are amending their breach notification laws to include biometric information. You have other states that have variations of it. You have the Internet Privacy Act in Nevada, and in New York they have the SHIELD Act, which is the Stop Hacks and Improve Electronic Data Security Act. Okay. Paid leaves. So we had many states that are looking at adopting some variation of paid leaves. Maine will take effect January of next year. Massachusetts has paid family and medical leave. Michigan and Duluth, Minnesota have paid sick and safe leaves. Nevada has implemented an anytime off leave. New Jersey has paid family medical leave. And in New Mexico, they have paid leave for any reason. In New York, they have paid family leave benefits. And then you have in Westchester County in New York, paid safe leave and a paid sick leave. Rhode Island, they have the paid sick and safe leave. And then you have in Texas, you have Dallas, San Antonio, and Austin, who have all implemented their own variation of a paid sick and safe time act. Dallas is the only ordinance in Texas that is actually in effect, and that went into effect December 1st of 2019. The others are currently under legal challenges. These are definitely trends we consider to be growing in with as we move into the 2020 and 2021 years. We're looking at expansion of paid family or medical leave, and parental leave policies are growing in popularity. Let's take a look at some leave benefits. And these aren't necessarily paid, these are unpaid leaves, but it gives the employees the opportunity to take time off and without pay or using some of their other paid benefits. California has implemented a new Parental Leave Act. District of Columbia, reasonable accommodation for domestic and sexual violence victims. Maine had several emergency responder leave, search and rescue volunteer leave, veterans medical appointment leave. Maryland has adopted an organ and bone marrow donation leave. New Jersey has a domestic or sexual violence victim leave. New Mexico has a kin care leave. New York has domestic violence leave and a boating leave law. North Dakota implemented emergency responder leave. Oklahoma voting leave. Texas jury duty leave protections. and Utah emergency responder leaves. Pregnancy and lactation accommodations continues to be a focus. And for example, California had recently revised their provisions, and all the other states listed made either an addition or revisions or adopted pregnancy and lactation accommodation laws within the last year. Salary history band. As we talked about that, this is also something that we'll see to continue to grow. We have Illinois, Connecticut, Hawaii, Kansas City, Missouri. I believe St. Louis is looking to pass something in their legislation soon. Nebraska, New York, where you cannot ask a new hire about their salary history. Also, Ban the Box is coming back around. That's the name of, that is the situation where the employers cannot consider a job's candidate's qualification, must consider a job candidate's qualifications first without the stigma of asking them about a conviction or arrest record. So in St. Louis, I was looking at my information here, St. Louis, Missouri just passed, effective 1/1 of 2021. They will have a ban the salary history. And Maryland passed a statewide Ban the Box effective 1/1 of 2020. So let's take a look at drugs and alcohol. Support for marijuana legalization continues. And the hemp and CBD products continue to grow. What's even more challenging is each law differs as to the maximum amount of THC that CBD product may contain. So looking here, you've got 17 states that have laws allowing CBD use, and each one can have a different law that says the amount of THC that can be contained. You have 33 states that have medical marijuana laws. Recreational marijuana just became legal in Illinois on 1/1. You have many other states considering it. Pre-employment marijuana testing. Nevada just passed a law that prohibits pre-employment testing of marijuana. And New York will ban the pre-employment testing effective May 10th. Medical marijuana continues to get protection under certain states. New Jersey and New Mexico amended their existing medical marijuana laws, and Oklahoma passed legislation to clarify the employer's right with respect to medical marijuana users. So let's take a look. There's several states that implemented many different law changes. And so we're going to take a look at some of the top ones. And if you don't see your state on here, or if you need additional information, please put that in the comments and we're happy to get that for you. In 2020, new employment laws that went into effect in California, they have the Flexible Spending Act notification law, California Labor Code for employment agreements. They amended their Consumer Privacy Act. They passed the hairstyle discrimination. They codified their ABC test for independent contractor analysis. They expanded their anti-harassment training requirements. They expanded their paid family leave. They mandate gender diverse board of directors. And they implemented employer obligations when it comes to wildfires. In Illinois, the Cannabis Regulations and Tax Act went into effect. The Workplace Transparency Act, which imposed a variety of restrictions and obligations on employers relating to workplace discrimination and harassment, that created significant changes to the employment landscape in Illinois in 2020. There's restrictions of confidentiality, non-disclosure, and non-disparagement clauses, mandatory sexual harassment training, harassment discrimination based on perceived protected characteristics will be expressed and prohibited. So it no longer has to be the actual treatment, it could be perceived. Non-employees such as contractors and consultants are now protected from harassment. Expansion of the working environment. It's no longer, harassment claims are no longer limited to the physical location where an employee is assigned to perform their work. It requires additional training for bars, restaurants, and hotels and casinos. It now recognizes gender violence and allows employees to take leave under VESA for gender violence. And effective in July of 2020, it will require mandatory annual reporting. They also, under Human Rights Act, expanded their coverage, that the employer used to be 15 employees, it's now 1 or more employees. They have their minimum wage increase, the race is on to $15 per hour. Annual report for diversity disclosure for corporate board memberships. Predictive scheduling requirements for Chicago employers. The City of Chicago and Cook County paid sick leave was amended effective July 1st of 2020. It will apply to all employers with at least 1 covered employee, regardless whether the employer has a Chicago work site. Cook County, 5 counties have opted out, have now reversed and withdrew their opt-outs and will now be covered under the Cook County requirements. Artificial intelligence video interviews. The Illinois Healthy Workplace Act, SB 471, seeks to create statewide paid sick leave obligations in 2020. This bill just passed the Senate on May 1st of 2019, and it's sitting in the House of Representatives. So there should be more to come on this one. We're thinking that that one might come to head in 2020. And the additional key reminders from 2019 that still has an impact on Illinois employers in 2020 is the biometric information, lactation breaks, and the expense reimbursement requirements. In New Jersey, they expanded their family and safe leave. They mandated panic buttons for hotel workers, mandated transit benefits, and restrictions on pay history inquiries. In New York, they enacted the SHIELD Act. They expanded protection for domestic violence survivors. They also placed more restrictions on pay history inquiries. And in Westchester County, they enacted the paid safe time. So with all of this and all of these changes and how they continue to go, how can you stay on top of all of these changes, especially if you are a multi-state employer or if you have employees that work remote within these other states? So we'll give you a few action items or a few items that will help. So first of all, with your employment application, you want to have every applicant complete and sign a data and employee application. That's probably one of the most important steps that you can take to protect your business for a variety of reasons. And you want to make sure that you have incorporated all state and federal requirements, such as if you offer employment or you do applications in states that ban the box or salary history. One suggestion is to change your application to say salary expectations. Ask them what their salary expectations are versus the history. In any event, it's recommended that you have your application reviewed by an employment attorney or a consultant on an annual basis to make sure you're keeping it current. The employee handbook. You want to make sure you're providing your employees with a handbook which outlines all your basic policies. In many cases involving employment cases, one of the first questions your attorney will ask you is, does your organization have an employee handbook? Why? Because if you're involved in employment litigation, you must be able to prove that you not only have official policies, but also that these policies have been communicated to your employees and that they have agreed to follow them as a condition of their employment. It is recommended that you have each and every employee sign an acknowledgement stating that they have read and understand the contents of the handbook. You want to make sure that you're updating it frequently. And you want to make sure that you're training your managers on the policies and procedures that are in that handbook, understanding their obligations, and that they are administering it consistently. Reference checks and background checks. It's recommended that you always do reference and background checks on all applicants and potential employees. You can't pick and choose. That's where it will fall into discrimination. Keep up your efforts to check an applicant's experience. Studies show that a third of job applicants misrepresent their qualifications, such as their education, work experience, certification, and so on. Make sure that you are consistent in verifying the candidate's qualifications. If you're doing a background check, it must be position specific. If you don't do it for everyone, make sure that you're doing it based on the position that requires it, or it could lead to a discrimination suit. Again, be consistent, use criminal background checks for similar employees' positions. And before requesting a background check from a third-party investigator, you want to make sure that you obtain the applicant or employee's written authorization to request the report and tell the applicant in writing that the information you obtain may be used as a basis for an employment decision. You want to make sure for workplace violence and safety that you are doing background checks to make sure that you are providing a safe environment for your employees. Okay, interviews. Be careful of what you're asking in an interview. You as an employer must provide equal employment opportunity to all qualified candidates without discrimination. So to protect your organization, only ask questions that are strictly job related. You may want to have a set of questions that you provide that are used as a standard format for all interviews. And you want to make sure that whoever is conducting your interviewing has been trained and they are constantly updated with changing in legislation and laws, especially with the salary history, or if they're using any type of artificial intelligence when they're doing any hiring, video interviewing, things of that sort. You want to make sure that you're staying compliant on all of the different state and federal requirements. Job descriptions, you want to make sure they're accurate. Written job descriptions are often used as evidence to defend against cases brought under various discrimination laws, especially ADA, Americans with Disability Act. It also gives your employee a clear idea of what's expected of them. It's difficult for a terminated employee to claim that he or she didn't know what was expected if she has an accurate job description and clearly defined expectations that have been communicated. Best practice is to provide a copy at the time of hire and even have the employee sign it. Make it a part of your annual review process and have the supervisor employee review it. Make sure it's current and sign off. And as an employer, this also helps to keep your job descriptions current. Form I-9. As the Department of Homeland Security continues to keep the immigration stance at the forefront, it's important that you are staying compliant, using the correct forms, having every new hire complete the I-9 form within 3 days of their hire. Best practice is you conduct a self-audit program so that you are constantly reviewing and making changes so that if someone does come knocking on your door, that you feel confident in what you have. Okay. Looking at your anti-harassment policy and training, you want to make sure that you have a well-written anti-harassment discrimination prevention policy. You want to make sure that it does include tiered processing for how they report complaints, has your no retaliation clause, and it identifies how the investigation process will be handled. Make sure that you develop and administer anti-harassment training for all of your staff members. Establish a system to track your adverse judgments and decisions and settlements, especially if you're in the state of Illinois or any other state that has mandatory reporting. And you want to make sure that when you are doing this training, that you are looking at diversity and awareness and incorporating that in your types of training. And remember that you need to set the tone from the top. Training on diversity and awareness helps support your anti-harassment training and policies. Okay, take a look at your employee files. Are they current? Are you compliant? Do you have a file on everyone? Do you have all of the required forms that you need? Are the proper documents being retained in those files? And are your supervisors or managers maintaining files? If they are, can they be admissible into court? Look at your overtime pay and your DOL concerns. Pay overtime for all workers that work over 40 hours that are classified as non-exempt. In the new year, particularly in Illinois, considering the state's increased penalties for wage and hour violations, it's critical for employers to review these changes carefully to determine whether any of the classification changes are applicable to your workforce. Some top scenarios that we've seen is violations, working off the clock and time tracking issues, time spent in training, travel, or volunteering for activities during work hours or work days. Make sure that you're paying them for that. Automatic deductions for lunches and breaks. If they're not taking a lunch, are you deducting them anyway? Rounding rules that favor the company and not the employee. Time edits by supervisors without the employee's knowledge. Checking email or texts on the phone outside of work. And that is a big one, especially if you allow your employees to have access to email on their smartphones or devices. Coming in early or leaving late, but not punching in or out accordingly. Okay, these are all classic violations of the Department of Labor, so you want to make sure that you have the right practices in place to catch that. Some top issues to look for under the Fair Labor Standards Act. Exempt and non-exempt and independent contractors. Are they correctly classified? Whether you're offering meal and rest breaks in accordance with the regulations. Looking at work performed off the clock as we mentioned, checking emails, and making sure that your overtime pay is handled correctly. Are you using the right regular pay calculations? And a bigger one, especially in the state of California, independent contractors. If misclassified, keep in mind that employers are liable for payment of back taxes, unpaid Social Security, Medicare contributions, unemployment insurance, workers' compensation premiums, not to mention penalties and interest. For family medical leave, you want to make sure that you are explaining to your employees their benefits. Keep in mind the employee doesn't have to ask. If the employer is aware of a situation or sees a pattern, they need to be educating their employees and making them aware of benefits that are available to them. Make sure that your organization is properly tracking it, and keeping in mind that sometimes the state laws and federal laws are different, and so you want to make sure that you're giving the employee whatever is more beneficial to them. Excuse me. Performance management. Making sure that you have a program in place that you're providing ongoing feedback to your employees and that you're documenting your employees' performance. Employee complaints. You want to make sure that you have a process for capturing your employee complaints and that you're acting on them immediately. And if you, as a manager or supervisor, receive this complaint, that you're notifying HR, that you document the concerns, you don't make any promises, and you follow up as requested by a supervisor or HR. More importantly, listen. Provide your employees with information on where to go, how to file a complaint, and how they will be handled. And make sure to emphasize your no retaliation policy. Other actions that you could take: review your existing policies and agreements, anything that includes confidentiality provisions. Review all of your future employment agreements. More importantly, train all your managers and supervisors and human resources staff on all provisions and changes. And keep in mind that additional action items could be required since all of these vary by state. So with employee relations, the management role, it's make sure that they understand the policies and procedures that affect their staff. They need to be alert and open, be consistent in their administration, be thorough, communicate concerns immediately, maintain communication with the employee when they're going through any process, always utilize human resources as a resource, and make sure that you're following up. So let's look at our third polling question. What do you foresee to be your employer's biggest challenge in 2021? Rising healthcare costs, recruiting for the required skill set and staff retention, technology with the automation and process improvement, maintaining all of your compliance requirements at the state and federal levels, or cybersecurity. Again, rising healthcare costs, recruiting for required skill set and staff retention, finding that right person with the right skills you need, technology automation, maintaining compliance requirements, or cybersecurity. Okay. All right. We're going to close the poll. Right. So looking ahead to 2021, 21% are concerned with the rising healthcare costs. 38% recruiting for the required skill set and staff retention. 10% with technology and automation. 26% maintaining compliance requirements, and 4% with cybersecurity. No surprise there. The top two I thought were definitely going to come through. So that concludes our presentation today. Now we'll take some questions that have been coming through. We have 5 minutes, so we'll take a few questions. Okay, the first questions that came through. Can I ask an applicant to complete an I-9 prior to being hired? That's a good question. You don't want to ask an applicant to complete an I-9 prior to making a job offer. For one reason, primarily, unhired applicants can use that I-9 information to allege that you discriminated against them. So if you're filling out that information, they may say that you used that information and that's why you didn't give them the job. Okay. Second question. The duties test that's used to decide overtime eligibility talks about determining the employee's primary duty. How do we determine that? The primary duty, you're looking for their most important duty, the reason you hired him or her. So is the person being hired as a supervisor, or are they going to be considered another set of hands maybe on the assembly line? You want to look at the relevant importance of the employee's exempt duties versus their non-exempt duties. The amount of time spent performing non-exempt work and how much the supervision is exercised over the employee. A good rule of thumb is to look at whether they're going to spend more than 50% of their time on exempt duties. But there are questions that you can answer on the Department of Labor's website. You can go there and it will walk you through the steps that you can answer some of those questions. Okay. Another one that just came through, can a business require employees to use direct deposit of paychecks? So there are some laws that say employers can make direct deposit of employees' pay mandatory, but most states prohibit you from requiring that, requiring your employees to use like a direct deposit or pay card program. So you'd really need to check your state laws before you're making that change, especially if you have employees that work in various states. Okay, what do you do if an applicant volunteers their salary history information during an interview? If you're interviewing somebody from a state that has the salary history ban. If you have somebody that volunteers this information to you, I would recommend that you remind them that they're not required to disclose this information. I would make a note that the applicant volunteered the information, and I would follow up with a question to ask them what their desired compensation is for that position. Okay. Another one, got time for just one more. Okay. Can we ban personal cell phones at work? Employees don't have the legal right to carry cell phones at work. You can certainly require them to place the phones or any other electronic devices in their lockers or in their vehicles or some other locked location. While this may seem to be unnecessary to some employees, personal digital devices such as an iPad or iPhone or cell phone can be very distracting and even dangerous, especially if the employee is driving or operating some type of machinery. You also don't want employees photographing any of your sensitive company materials or recording conversations. So you can definitely require them to not have that on their person while they're at work. So we are now at the top of our hour, and I would like to thank everyone for your participation and for attending today's webinar. If you have any questions, put them send them to us and we'll be sure to get them answered and follow up with you. Thank you. Have a great day.